Hey guys, how are you? This is Ishai Breslauer, your host of the CRE Shark Eye Show. Hope you guys are doing well today. We're going to talk about something a little different today, meaning every show is different, every guest is different, but our guest today is an attorney who specializes in many, many aspects, and real estate is one of them in a different format than we know, and we're going to hear about that. We're going to talk about securities. We're going to talk about startups. We're going to talk about many other things. Startups we talk about because we usually talk about PropTech also. But without further ado, Jonathan Feniak, thank you for being with us.
Thank you so much for having me. It's a pleasure.
Excellent, excellent. You know what? Then before we even dig into your story, if you could give us a 2-minute elevator pitch about your business and about your practice.
We are really a legal tech company. We're focused on asset protection and privacy. And the basis, sort of the starting point for asset protection for most folks is going to be an entity, form an LLC, form a corporation. We form over 2,000 companies a month for our clients, many of them based in Wyoming. Wyoming has fantastic asset protection laws. And so they will form a Wyoming holding company and subsidiary companies in states all over the country. A huge part of that for our clients is privacy, making sure that they are very wealthy, many of them, but people should not be able to see how wealthy you are with a search on the internet, with open corporates or something else. It shouldn't be at someone's fingertips how much property you own. We also focus on asset protection trusts. They're sort of the gold standard in asset protection for an individual. When you have business-related risk and liability, entities do a good job, especially with the holding company structure and insurance, of protecting you from that risk and really being ruinous when it comes to your personal finances. But there's a certain amount of risk each of us have as we walk around in the world. And if you're a real estate developer or a real estate investor, you are likely to be named as an individual in any litigation against one of your companies. They're going to say that you did something separate and distinct from what the entity itself was doing, or you're so intertwined with the business. And so how do you protect your personal assets from that personal liability? An LLC is really not going to help. But Wyoming, there's been this arms race among various states to create incredibly protective trust and limited liability company laws. And that's really where we live, is helping our clients protect their assets. They've worked so hard to grow and build so that a single event does not ruin them.
So that was one of the most elaborated 2-minute elevator pitches that I've ever heard. That was good. Thank
Sorry.
you. No, it's great. I'll tell you, and it just shows us that we have a lot to learn today, especially. So that would be great. You're going to educate us in some stuff that we actually need to know. The one thing that I would like to start with is, how did you get into this?
Yeah, so I'm actually a third career lawyer. I think a lot of lawyers. There's some of us out here who I think bring a great deal to the profession because we were out in the real world. We saw how things can go wrong, and we had real skin in the game. I think a lot of lawyers, if a lawyer goes from undergrad to law school and then becomes a lawyer, what did they actually see? They know the law inside and out, but do they know the realities of a negotiation? And when you've got someone else in a business partner when things are going wrong. I started out in operations in Manhattan. I was a district operations manager for DHL. I ran all of Lower Manhattan and ran operations on September 11th. And so sort of, under pressure, didn't fold, but also worked with a lot of guys who were in the military. And the way the military approaches things, I think a lot of us can adapt in our personal lives. And things like, they say 1 is none, 2 is 1. What does that mean? Well, one LLC may not be enough. 2 LLCs would be equal to 1 LLC, right? So having a holding company, 2 LLCs. That was a very difficult industry to be in. The hours stunk. I spent, so many days at the airport on the tarmac, at 4 a.m., at 3 a.m., waiting for planes to come in and stuff, and the weather and so on. And so I began to pursue an MBA, got an MBA and went into finance. was raising money for hedge funds and also working to invest money for those hedge funds. So finding deals, looked at a lot of business plans, invested in a lot of companies. Last count, over $100 million of transactions that I was the lead on, and then raised hundreds of millions of dollars for those hedge funds so that they can invest that money. Moved on from there and became a financial advisor, working with many of the same high net worth clients, but doing more traditional things. I was at Wells Fargo Advisors. I was a licensed 7 and 66 securities broker, a registered investment a professional, and also insurance licensed. And so I understand that side of the business, work with a lot of wealthy folks, how they approach investments and what it is they're actually looking to get out of it, which many of them it is to do well, but protect their downside. They realize that things do happen over the course of an investing career. When you get to the point, perhaps, that you're just in stocks or bonds, there isn't a lot of risk which flows from those investments, but many of them would have a portfolio that was, was half in stocks and bonds, sort of low risk from the personal liability perspective, but then the other half would be in investment property, would be in commercial real estate or single family rentals, multifamily, those kinds of things. Tremendous amount of liability comes out of those types of investments. And I got tired though of the world of finance. There's all this sort of fintech going on there, and it wound up being where the Wells Fargo and not to ding on Wells Fargo Advisors, but they wanted the financial advisors bring in the client, get them in, and then move on to the next. And I wasn't really learning about my clients' issues and really coming up with new solutions. Right? I never was able to come up with new solutions for my clients, or rarely. And so I went to law school in my mid-40s and got a law degree focusing on what I'm doing now. So business law, trust and estate law, and getting a firm foundation from the legal side, knowing that I understood sort of the real risks of those types of endeavors and where the risk is going to come from with that next business venture or real estate investment. And began working with, right out of law school, began working with the team I'm with now. We form, thousands of companies for our clients every month, and we're really niche focused, asset protection and privacy. If you want someone to negotiate your next business deal or the sale of your company, we're not your guys. What we're going to do is work with you at the inception of the companies to make sure that you're going to be protected if things don't work out. Or if you have an existing investment portfolio or invest in an existing business, how can we enhance your asset protection so that if things do go wrong, you're going to walk away with not having lost everything and go on to fight another day. Having been, I'm not that old, but 3, 4, 5 crises over the course of my life already have ruined so many of my friends, whether they were in finance, whether they were in real estate, whether they were, pick it. There have been people who have lost it all during, the 2000 crisis, Y2K, or in the post 9/11 real estate market, or in the 2008 financial and residential or real estate collapse. There are I say my history, my friends, my clients. There have been those who have really lost it all and had to try to do it all again. And so I want to help my clients now not ever be in that place.
You know what? You gave us so much, and what I want to focus right now is on a question. Is there a size, because you said high net worth individuals and people who own a lot of properties and have a certain amount of portfolios, et cetera, et cetera. Is there a certain threshold, a certain size where you say from that point, you have to start worrying? I'll give you like a live example. Let's say someone who started with commercial real estate recently and bought a small multifamily, let's say a 10 unit. Is that in the category? A 5 unit is in the category. Only obviously
1 unit is in the category.
Because, okay, go ahead.
So if it's going to be 1 unit and that's it, you're done. I'm going to buy one place and I'm never going to buy anything else. Then fine, really don't worry about it. Insure up. If though this is the beginning of an empire, and I think most people in real estate, it sort of sneaks up on them. They start out with one, and next thing they know, they've got 10, right? Or they've got 20, or they've got 100 units that they're responsible for, that they have liability for. And so it's much easier to start out correctly. Doesn't cost any more to do it early, right? Get the structure established at the beginning, and it's much easier to protect yourself for the long term. I do have some people, people call up and I've got, 25 rental properties or 25 units, and they're all in my personal name, and there's no limited liability protection. What do I do? It's tough. It's tough, right? You're already known, or it's already known that you are a wealthy individual. Anyone can do a search, and attorneys have access to all sorts of databases where they can look and find out how wealthy is this person that I'm contemplating suing. And I like to listen in on calls with, plaintiffs' attorneys, do a lot of the continuing legal education, where you get people who are talking about, how do I decide to take this case? And one of the things that they do is they look and they say, how well heeled is this this defendant? Do they have significant resources that are going to allow us to sue above their insurance policy limits? And if they look in a database and see that you own 100 pieces of property, they'll sue for more.
Right. I want to stop for a second, because we're already going to the what people are thinking, how people are finding in the internet. That's a topic I want to touch in a second. But I want to ask you if you give us an example of a bad setup of an LLC or a corporation or whatever that could put person in a certain liability, and what would you do? If you could give us like a sort of a live example. Sure. What would you do from the very beginning? What you said, it won't cost more money. It will be beneficial for that company or the person to do that in order to protect themselves. If you could give us a live example of something that is done, I wouldn't call it wrong, but not right.
Right.
And where you come in and make it right. If you could give us like an example in terms of the structure.
So an example is that people set up an LLC and then don't treat it with any respect. They don't respect their entity. If you don't respect it, a court's not going to respect it. And the court is going to just hold you personally liable. They're going to say that entity is your alter ego. So what people will do is they form an LLC, they title the property in an LLC, but then they accept the rent checks in their personal name. The rent checks are coming in via Venmo in an account that's theirs. They go and they pay their landscaper. The landscaper mows their lawn at their house and mows the lawn on the property, right? So what they've done now is they've commingled the assets of the company with their own. Where is the distinction between the two? And a court will look at that and say, this isn't a real company. We don't know what's yours and what's the company's. So we're going to say that everything you own is the company's asset. That's something people come to us and say, I set up an LLC. What more do I need to do? Annual meeting minutes, right? At an absolute minimum. I want to see ongoing meeting minutes. When there's a contribution into the LLC, then there should be meeting minutes associated with that. If there's money coming out of the LLC, distributions, meeting minutes coming from that. If there's significant actions being taken at the LLC level, you're deciding what insurance carrier to go with, right? So you talk to 3 different insurance carriers, get quotes, you identify which one's best for you, and you make a decision. Meeting minutes for that. All of those things then are going to, number one, we've created a record of the business and what it's done. And they're also going to be protected by something called the business judgment rule, right? You've used your judgment to make a decision related to that company. You can't be faulted, or it's very difficult to fault you in the future for that decision. You chose this contractor to put in the set of steps. You screwed up, right? And you should be held personally liable because the contractor did a bad job. I'd use the business judgment rule. I interviewed 3 contractors, and this was the best one for the job based on the information I had available. But you made a decision based on that. If you fail to do those things, then you and the company are one and the same. The other thing that I see people do is the commingling of funds. They are maybe they are accepting rent payments into one account, but then they go and they're making their personal car payment out of that rental account, right? The one that collected the income on the business, or they're paying personal expenses out of it. They treat it as their personal piggy bank, and it shouldn't be. If the business expenses, valid business expenses, are paid out of that account, all the income goes into that account, and when you're ready to spend it, meeting minutes for a distribution, 5,000, 10,000, 100, whatever the number is, that comes out to you, and there's a record showing it's not me spending the money out of the company. This was my profit share, which was distributed to me. And so those are small things that you can do with your company, record keeping from the start and maintaining that distinction between yourself and the company. You are not the company. Even if it's a one-person LLC, you're not the company. So what we offer our clients is these easy access to these kinds of documents, right? How do I prepare meeting minutes? It doesn't need to be anything fancy, but you just need to do it, right? So they go into our client portal. If we form your LLC and you sign up for additional meeting minutes, pay a small fee, and then you can create unlimited additional meeting minutes, fill out a small questionnaire, and then documents are generated for you. You electronically sign them. And what I like to imagine is that I'm in a courtroom and the other side is saying this is really just the LLC is this person's alter ego and they should both be held liable, because they will. The plaintiff's attorney will fight for that, but you have a stack of documents that you're showing them. Here's the 100 meeting minutes we've had over last year, Your Honor. It's obviously a real company. Let's not even talk about this anymore, right? And if you show them your bank account, if they want to see your bank records, and it's highly probable that they would be able to see them. It's going to show that there is nothing but valid business expenses coming out of that business bank account. You've taken away all of their ammunition in terms of being able to hold you personally accountable for the liabilities of the business.
But you know what? That sounds more like a problem for a smaller business, meaning larger businesses don't have that problem because everything goes through their corporations, LLCs, et cetera, et cetera. The one who is, I would call it in between, who's starting up and has already a few properties, has already a few things going on, have a few businesses, that type of a person is in danger because he will probably, it's more likely that he or she, they will mix up the business and the personal life. And that's where, good. But you know what? You educated us with something that is really tremendous. And the meeting minutes, something that I never thought about it. So that's an incredible revelation. That's an incredible thing. The one thing I would like to touch, and we started talking about it right before we started recording, if you could just give us a little bit, enlighten us about what is asset protection, what is it, and what is the whole thing about that you guys, help out.
Well, there's two kinds of liability that most people are faced with. One's going to be, I call it bottom up liability. Somebody slips and falls on your piece of real estate. They're going to sue the entity. They're going to go after the insurer there. If they're not satisfied with the amount they're being paid, whatever assets are inside the LLC, they'll go after them. And then if they're still not satisfied, then they're going to try to get to the owners of that LLC. You set up a holding company, which is the owner of that company, which actually has the liability to protect you from personal risk. So we've set up they effectively have to win twice to get to you and your personal assets. Highly unlikely, especially with a Wyoming LLC. That kind of liability protection is one that's most people are familiar with. The other kind is the kind that we each have as individuals walking around in the world. Are you just a target because you're a wealthy individual? If Beyonce gets in a car accident, they're suing her for $10 million, even if it's just a fender bender, because they know how wealthy she is, right? Do they know how wealthy you are from just looking you up on the internet? Hopefully they aren't able to. If you've worked with us, we've helped you establish entities which are not listed in your name. You are not known to be a wealthy person. I guess if you're driving your Ferrari around and you hit them with your Ferrari, they're going to know. But generally, they're not going to be able to find out how wealthy you are because we assist with setting up entities that are formed privately and anonymously. Now, what if they do, though, know that you're wealthy? It's already too late. You can establish an asset protection trust, and I call this top-down liability. An asset protection trust or a Wyoming holding company, where if they sue you as an individual, can they get to those real estate holdings you have or all of that cash and investment property that you have? And with a Wyoming asset protection trust, those assets are going to be shielded from the claims of your personal creditors. If you're asked, what assets do you own? There's some sort of asset disclosure at the end of a litigation. The answer is going to be nothing or very little, maybe your primary residence, right? And what's in your checking account. Anything you had placed into a Wyoming asset protection trust You could say, I don't own that. You don't have a property interest in those assets. You are not the owner of them. And you can, without committing perjury, say, I don't own them, right? They're not mine. I don't have the ability, even if I wanted to, I couldn't pay you with these assets. The other thing that you can do is, if you're not quite ready for an asset protection trust, because those are even more complicated and there are quite a bit of expenses associated with them, having a Wyoming holding company as the owner of all of your subsidiary LLCs provides a tremendous benefit, because Wyoming has something called charging order protection. And it is the sole remedy of a judgment creditor in Wyoming. What is charging order protection? Charging order protection means that a plaintiff is not permitted to break into your LLCs and foreclose on its assets or take your membership interest in those LLCs. The best that they can do if you have a Wyoming LLC is get a charging order against it. And that means that if there's distributions which are made, that plaintiff will receive them. They snatch them up, they take them away from you, but they can't force a distribution. And it actually, you can create a situation where that plaintiff who has a charging order, that judgment creditor, that you don't actually make distributions. They just have an allocation of the profit. So they basically, anyone in real estate knows about phantom income, right? Who's to say, wait a minute, I have all this capital gain I need to pay tax on, but I never got any money. You can do the same thing with that judgment creditor holding a charging order. Congratulations. The company you have a charging order against made $1 million in profit, but the members and managers have decided they're going to reinvest that in a new piece of property. But it's going to take 6 months to find that new investment. Here is a K1 for your pro rata share of the profits. Go pay the tax on it. At some point in the future, you are going to get a distribution, maybe, but pay the taxes on it now. For that reason, very few judgment creditors will take or get a charging order against a Wyoming LLC. That's why you have a holding company in Wyoming. Let's talk about if you had a LLC in New York. Somebody sues you,
or Delaware for that aspect.
Or Delaware, right?
Because the Delaware is a very desirable location for LLCs. A lot of people are going there naturally, and I don't hear many people who are taking LLCs in Wyoming. If you could, elaborate.
I can absolutely talk about that. And there's been, so Wyoming was actually the first state to recognize LLCs. They have a great body of law when it comes to LLCs. There is a feeling by many that they need to be in Delaware. It's some sort of cachet associated with, and I would agree with that. If you are raising outside capital, then a Delaware LLC is the place to be. It has a court of chancery, and investors in real estate like to know that they're going to get a speedy adjudication of any internal conflicts with the members, managers, and so on. But Delaware tends to be more expensive, for a very wealthy individual. Perhaps that's not an issue, but there's also not the focus on protecting the interests of the members from outside claims, right? There is more of a focus on how can we create a fairer playing field for investors and for the company. Wyoming has something called a close limited liability company. This is not available under Delaware law. And a close LLC, I call it a kitchen table company, where you have a husband and wife, a couple of friends, a small group of investors who are forming an LLC. They're not going out and raising capital from Silicon Valley. They're not going to be raising money from outside investors. And what it says is that there's a very light record keeping requirement on the company. It can't be used against you. Those things I talked about, meeting minutes and annual, all those things, it can't be used against you to pierce the veil and come after you personally if your records aren't pristine, right? In other states, failing to maintain appropriate records, statutorily mandated entity records, can effectively lead to a veil piercing and make you personally responsible. So thinking about what this LLC, this holding company you're establishing, is doing, are you raising outside capital, right? If you are, Delaware is probably the place to be. If you're investing your own money or money with a close group of friends or co-investors, Wyoming is the place to be. It prevents those bottom up plaintiffs from getting to you, and it provides that charging order protection. It's focused on asset protection for you, the members, not protecting third parties or allowing third parties to go after the assets in that LLC.
And I'm assuming that you're giving service also for those who have LLCs elsewhere, obviously.
Yeah, well, I'm licensed in Wyoming and Colorado. We have attorneys who are licensed in, who work with us, who are licensed in Florida, New York, California, New Jersey. But many folks come to us for that Wyoming holding company, and then they have separate real estate counsel in Ohio or in Arkansas or wherever the heck they have their property. We will set up the LLCs. Most of those subsidiary LLCs are going to be ones where it's really just acting as a liability blocker, with the ownership predominantly occurring at the Wyoming level. What Wyoming is the premier location for a holding company for a closely held company. This close limited liability supplement is a huge benefit.
I want to shift gears a little bit and go to the aspect that you have a lot of experience with, and that is a lot of people in real estate are raise capital, and the whole aspect of broker dealerships, securities, et cetera. Can you give us a little bit of information what they have to be careful from? Why do they need a person such as your firm to help them out with that? Go ahead.
Yeah, well, what we don't do is securities offerings, right? But what we help our clients figure out is, do they want to even do a securities offering? There's some small things with small groups. I mean, if you're going and you're looking to raise, tens of millions or hundreds of millions of dollars, then you absolutely should go and, hire a law firm, which can provide you with all the documentation you need and protect you from, committing securities fraud, as well as all the liability that comes along with it. But there will be folks who are like, yeah, well, there's me and my 5 family members, are going to start investing in real estate together. So I'm going to do everything. They're just going to give me their money, and I'm going to go find the properties. I'm going to manage the properties. And I tell them that's securities offering, right? There's this Howey test. Everyone's heard of it, this old SEC case. In a scenario like that, I say it's possible, right? Don't make it a securities offering. If you make it a securities offering, you have, number one, the registration requirements and the cost of doing it. And number two, you are exposing yourself to all this excess liability in the event that things go wrong. Saying you're like, I'm not going to go do the securities registration. If things go wrong, you're going to be brought up not only in securities fraud charges, but all sorts of other things. You're going to have a whole mess of trouble. So how do you do that raise with family members or a smaller group and structure so that it's not going to be treated as securities offering, right? It's going to be involvement of those individuals in the decision making for the entity. Yes, there's going to be one person who's making the majority of the day-to-day decisions, but you set it up as a manager managed LLC, not member managed. The manager has certain responsibilities up to a certain dollar amount or certain transactions they can or can't do. But then you're going to make those members of the LLC get together and talk about the investments, and you're going to keep meeting minutes for it, right? So now they're driving the entity as much as you are, right? In terms of the long-term growth and prospects of the company. That removes it from a securities offering because it's not solely from the efforts of others. Everyone's involved. And they can at some later date say, I had no idea what was going on with this investment. No, here's the meeting minutes. You were there. You made the decision about whether to buy.
And can it be done also with an LLC from Delaware, for example?
Yeah.
Or only from Wyoming? Any LLC?
Any LLC, right? So if you want to do a securities offering and there's the capital raise required to do it, then great. Just don't inadvertently get yourself to the point where you're doing a securities offering and didn't intend to. Right. And that's that dividing line, the one that really trips people up is, who's doing all of the work? If everyone's involved and everyone's participating, it's not a securities offering. It's just with a partnership. We opened up a taco truck, and you and I are deciding whether we're buying ground beef or ground pork every day. Right. It's very similar. Is it that's not a securities offering? That's just a partnership. And so who's making the decisions? Don't just take people's money and then tell them you're going to handle everything and invest it for them, because then you've likely moved over into a securities offering and you've got a whole maybe it makes sense, maybe it doesn't, but there needs to be some real thought put behind that to make sure you're not inadvertently entering into a securities offering or offering security.
Moving ahead, we spoke also, prior to starting, the show, we spoke a little bit about startups, and I saw that this is a big thing in your LinkedIn. You talk about startups, and a lot of our listeners, people I deal with, I personally deal with that in the prop tech industry, property technology industry. So startups is a big thing today that is obviously related to the real estate part, because a lot of people are coming with all kind of technology solutions for the construction industry, property management industry, acquisitions. Every single thing is becoming digitized and becoming a tech, becoming a startup. Tell us a little bit about, from your side of things, what can you tell people who are getting into startups? Before you start, just want to tell everybody, guys, this show is not in any way, advice or legal advice or any single thing like that. You'll have to actually contact Jonathan directly and hire him in order to do that. This is just not an advice. We're just schmoozing. We're just talking here. So, right. Jonathan, go ahead.
Yeah, and this happens all the time, right? So people say, well, Google's in Delaware, so I need to form a Delaware C Corp, right? I need to form a Delaware corporation and make it a Delaware C Corp right from the start. I just have an idea, but I'm going to go do that thing. Don't do it. Don't do it. Start small. The path I love is one where you do a Wyoming close limited liability company. It's you and your partner. You're bootstrapping this thing. You're proving out the concepts. As things are progressing and you're like, man, we could use a little bit of money. Think about what I just said. Don't make it a securities offering yet, right? Get people who are going to be, maybe they have some money and they can participate in the company, right? So you're not going immediately to a capital raise. It's going to cost you $25,000 to do a securities offering. Where's that money coming from? Your pre-revenue. It's challenging to do that. So I think you start small. Start with a partnership. Bring in some partners, true partners, not just passive investors. Those people who are going to add value and are participating in the meetings and helping drive the direction of the company. Then when things are start to go well, you can make the decision, okay, we're going to start raising outside capital. At that point, you could do something called a continuance or domestication of your Wyoming company to Delaware. And you can move companies. This is something people don't know. Start in a low cost, easy, friendly jurisdiction like Wyoming. And then as you're growing and looking to take outside money, at that point, you can domesticate or move your company, keep your EIN number, keep your bank account, keep your data formation, keep your name, as long as it's still available in that other state, and move the company to Delaware. Maybe you move it to Delaware as an LLC, right? You've got some investors who like the certainty of the Court of Chancery. And they're still willing to invest in a partnership and they're going to be involved, but they feel more comfortable with Delaware law because they've got 10 other investments they've made, or they're participating in 10 other companies. They want to have one jurisdiction. So you move it to Delaware, from LLC in Wyoming, LLC in Delaware, and then things are starting to go well, right? And the company is going to raise some more money. At that point, you could do a conversion from an LLC to a corporation. Right? You could change its tax status. And so there's this building process. Each of those things takes more complexity and there's more cost associated with it. Having a corporation or an LLC in Wyoming, the state fee is $100 to form it, and it's $50 a year to maintain it. In Delaware, for a Delaware corporation, your annual fee could be up to $250,000. Right? Depending on how many shares you've issued, the assets of the company, and so on. And so do you want to take on that cost right at the start? Does it make sense? You're incubating this thing. There's another thing under Wyoming law. It's called the series LLC. And there's folks who have, they have ideas in this startup world, and they're not sure if they're even going to work. And so what you can form is a series LLC, and for the cost of one LLC, you can get 10 LLCs. So a series LLC acts like a mini holding company structure. You've got your top level LLC, and below it, right at formation, you get 10 separate LLCs, but you're only paying for one LLC. And each of those separate LLCs could be a cool idea that you're going to incubate, see if it works out. If it doesn't work out, doesn't matter. Just let that one go. It didn't cost you anything additional. If one of them really takes off, you could take that one, move it into its own Delaware LLC or corporation. So don't get too excited or think that you're going to be the next Google. I hope you are. But when it comes down to it, most companies are going to fail at the early stages. Do it in a judicious way and make it easy on yourself, as opposed to trying to go to a very complex C Corp corporation, Delaware structure that's going to be very expensive and complicated to maintain. You're probably going to trip yourself up at some point. Take it slow, start easy, and then build from there.
That's a great tip. And you know what? I want to tell everybody, you guys heard so many tips today, and I have a couple of more questions for you and your business, Jonathan. But I think that was tremendous advice, meaning that you gave to everybody, tremendous tips. And again, no legal advice here, no financial advice. We're just schmoozing and talking. And if you guys want to hear the rest as per how it can help your business, you guys should definitely contact Jonathan directly. Jonathan, I want to ask you another question, and it's more related to your business. Again, prior to this to the show, we started schmoozing a little bit, and we started saying that you want to digitize your process. You want to become a sort of a more you want to make it a modern type of a company that is more digitized, tech company, your legal company. Obviously, we're talking about moving to Puerto Rico, etc. If you could tell us a little bit about what you're doing. And how you're expanding, and what are your plans, and what in order to get get more market cap, getting into to the marketplace in your case.
Yeah. So prior to 2022, we were running the operations in 15 different states, right? Where we have 15 different websites. All of them or some of them were using the similar technology to handle the formation of entities and provide legal services or quasi legal services in all of those states. And we had started out we started out in Wyoming, and we're just doing entity formations there. And the company has grown. At the end of the day, we wound up with sort of a spaghetti of different systems for each state. And we made the decision in 2022 to start from scratch and look at where was the real value in what it is we're doing. And the real value is being able to efficiently form companies and provide legal services and quasi-legal services at a low cost to as many people as possible. So what we did is we hired a new tech team in Puerto Rico. We started up a new company in Puerto Rico, and that new company is really just focused on the technology that's powering all of those entity formation websites and companies in the US. And the idea here is that where's the real value in what we're doing? It's not having someone, and we accept tens of thousands of pieces of mail for our clients every month. We receive it, we open it, we scan it, we put it into the client's portal. That is a manual labor, and anyone could do that, right? Anyone could open up a piece of mail. What's the hard part about that? The hard part is the technology, which allows us to make sure it gets to the right client, that they're charged appropriately, that personal identifying information is shielded from hacks or otherwise. And so all these other things. And so we've recalibrated what it is we're doing, and really are focusing on the technology component. I'm still a lawyer. I still work with clients. I work with clients, and from Wyoming or from Colorado, and our other attorneys are working with them from other states. But it's really thinking about what is the core value that we're adding. And I think probably a lot of your clients, you can say, well, going and shoveling the sidewalk, that's not the value add part of the business. That's the easy part. How do you make sure someone is there? How do you make sure that they're shoveling when the snow comes? How do you make sure that they're paid properly? How do you make sure they have proper insurance and all these other things? That becomes the complicated part. And that's where the technology comes in. So we are with all the companies we're forming, I think a lot of other players out there, the clients have felt nickeled and dimed on their entity formation. And if you go to some of our competitors, it's upsell, cross sell. They're selling your information. They're doing all these other things to sort of monetize you. And we're not doing that. We're trying to keep it simple and add value for our clients, working with, providing real value, not selling you your information to the highest bidder, which I think many of them are doing.
And you spoke about upsells, and that's exactly what's happening. And we don't know anything.
Right.
And it's one of the things I would compare attorneys to when you go to the car shop. You go someone to fix your engine or something, and he tells you, oh, you have this and you have that, and you say, yeah, I have no idea what you're talking about. Then they can do whatever you. So it's very, very important to have not only a trustworthy company that you can go with, but having the right advice and not having all these upsells on the way, and to know that you're actually saving money, not only being protected, but saving and not overpaying. Jonathan, thank you so much for this. I really appreciate your time. This was phenomenal. And you guys can see the links above, below. Jonathan, if you could tell us, please, how everyone can find you.
Yeah, WyomingLLCattorney.com is our flagship site, and that'll allow you to form a Wyoming holding company, order or learn more about an asset protection trust, form anonymous LLCs in every state, and schedule time with an attorney, as well as we have paralegals who can assist you with our technology. They can't provide that customized legal advice, but they can provide you with the right documents that have been prepared by an attorney. We work on a flat fee basis. There's no surprises in our billing. You sign up for what you need, you pay for it, and then you have something that's really just going to deliver on what it is you're trying to do.
This is perfect. I love it. And we learned so much today. Jonathan, thank you so much.
Thank you very much. It was an absolute pleasure.
You guys, I hope you enjoyed it, and I'm going to see you in the next show.